Good evening. My name is Paparinskis. I am a reader in public international law here at UCL Laws, and I'm a chair for tonight's talk with the provocative title and no less provocative content: International organizations do not need to have members. I'm very pleased to be welcome Dr. Gerd Droesse as today's speaker. Dr. Droesse has had a long and illustrious career in international organizations for 35 years, including in senior as well as managerial positions in such organizations as Green Climate Fund and the World Green Economy Organization. And I think that the topic of his talk fits very well with a general approach to public international law that many people have historically taken at UCL Laws, looking at foundational questions of public international law, being somewhat irreverent of received wisdom when it does not seem to translate neatly into the accurate legal principles, and also being very closely connected to international legal practice. So asking the hard questions and with an eye to reality of international interaction between states and international organizations. Now, let me just, before I give the floor to Dr. Droesse, say one or two words about the procedure for today. Dr. Droesse will talk for about 40 minutes, and then you will have an opportunity to ask questions and answers. In the traditional Zoom fashion, you will be able to ask your questions not through chat, but via the questions and answers buttons. After talk, I will be asking the questions in this manner, and I think you can also, if you see questions already entered that you particularly like, you can vote them up so that they are asked first. That is really it for me. Dr. Droesse, the floor is yours.
Thank you very much for this introduction, and it is a great pleasure and honor for me to be able to give this presentation on the title International Organizations Do Not Need to Have Members. And the presentation profiles some of the theses of my book, Membership in International Organizations, which was recently published by TM Assa Press, which proposes rather far-reaching changes to a traditional concept of international organization. Traditional concepts are based on the establishment of the treaty, the distinction between public and private and governmental and non-governmental, the mantra that there cannot be an international organization without members, and restrictive concepts of subject of international law and international legal personality. They require generally that IOs possess international legal personality. Their autonomy is conceptualized with reference to the constituent agreement, and governing bodies are an amalgam of combined executive power. Finally, funding is provided exclusively or predominantly by states, and operational activities are implemented by public entities. While still relevant to international organizations with a treaty base, many of these preceding concepts are, in my view, no longer in line with the evolution of international law and the needs of the international community, and need to be revised for that reason. And I'm proposing, therefore, substantially new concepts of membership, subject of international law, and international organization and new representation mechanisms, funding structure, and operational modalities for international organizations. I would like to start directly with one of the core theses of my book, which was characterized probably correctly as somewhat provocative, which says basically that international organizations do not need to have members, and members do not need to be exclusively states and international organizations, but can also be sub-state actors, private sector entities, or other stakeholders. And one of the traditional mantras of international law is that international organizations need to have members. Professor Blocker states under the title that without members there would be no international organization. It is, of course, a truism to mention that there would be no international organizations without members. An international organization does not simply spring to life spontaneously, it must be founded. However, already in the next sentence, he concedes, strictly speaking, the international organization is not founded by its members. Those members only exist from the moment that the organization has been established. In my view, and as I've tried to explain in my book, the traditional mantra is incorrect in three respects. First, an international organization does not need to be established by a treaty, nor is there need for membership structures to be established by a treaty. Second, the parties to the treaty establishing an international organization do not need to become members of the organization. And third, an international organization does not need to have members, and in fact, there are organizations which qualify as international, even though they have not, even though they do not have members. Regarding the first proposal, I will illustrate this in the following, and I move therefore directly to the second proposition, that is to cases where parties to the constituent agreements do not need to become members. In fact, there are certain cases where members are not governments, but central banks, such as the Bank of International Settlement. But more fundamentally, there's no intrinsic need for the parties to the constituent agreement to become members. And Ratzelmatter, who was the former General Counsel of IFAD, illustrates this with the World Customs Organization, where a distinction between contracting parties and members is made, and with the Vienna Joint Institute, where a distinction is made between parties and members. But the clearest example for the above proposition is the CGIR consortium, because the agreement establishing the CGIR consortium provides in Article 1, the consortium of international agricultural research centers is hereby established as an independent international organization with full international legal personality. However, while the CGR is established by a treaty, the contracting parties do not even have the option to become members because members are exclusively the various CGIR centers. And this shows that a treaty can merely be a vehicle to confer international legal personality and privileges and immunities, and does not imply necessarily that the contracting parties to the treaty need to be members. And this has far-reaching implications, because following this CGI paradigm, it's conceivable that international organizations might be established with membership of sub-state actors, with membership of national regulatory agencies, and with membership of private sector entities and other stakeholders. And this paradigm can also be the basis for establishing entities without formal membership structure. In their traditional form, IOs are structured as clubs, with the constituent instrument defining club membership. And members have certain benefits, like representation, access to financing, procurement, and they have defined obligations, in particular to provide funding. However, the simplistic correlation of benefits and obligations based on club membership does not apply to IOs producing public goods or fighting public bads. I think you may agree with me that it would not be appropriate to allocate funding for assisting in the adaptation or mitigation of climate change, in fighting malaria and other diseases, or in fighting drug trafficking and other heinous crimes, based on formal criteria relating to the association of a country to a specific organization. In such cases, the funds must be used where they are most needed rather than based on formal criteria. Therefore, for organizations producing public goods and fighting public bads, membership is only of limited relevance. But in addition, even for traditional organizations, membership loses importance, for example, in the case of procurement, because it is questions whether the increased transaction costs are justifiable, and therefore the overall importance of membership reduces. And as I will set out afterwards, in case of organization producing global public goods or fighting global public ads, new funding mechanisms for these organizations are necessary. And just I would like to share with you one of my experiences from the time when I was the legal counsel and first general counsel of the Green Climate Fund. Because I previously helped the ADB staff member assigned to the working group drafting the governing instrument, and up to the third meeting of the transitional committee, the question was asked whether the GCF should have a formal membership structure. But what would have been the purpose of this membership, as there's no governing body, no plenary body through which the members can express their views? And it was probably for this reason that automatic membership, which generally is possible, was not produced. And I want to give you another example. The Global Fund to fight AIDS, HIV, tuberculosis, and malaria, which, as I will explain afterwards, in my view, is a new paradigm of dual and hybrid organizations. And this fund clearly cannot have a membership structure because the resources must be used where they're most needed, not based on membership criteria. Now let me come to the subject of membership. And here also, The topic of subject of membership is colored by state-centric concept, and it's generally accepted that states and international organizations are members. Sometimes dependent territories are admitted, and private sector entities, if at all, are only admitted to a very minor affiliate or sector membership. The questions whether sub-state actors or private sector entities can be full members of IOs is generally not asked, let alone answered. Let me refer to Oether, Professor Oether, who says, and I fully agree with him, that the traditional way how international relations understands the global order as a product of a set of unitary actors hinders an adequate conceptualization of the current legal orders. And as we all know, Anne-Marie Slaughter portrays a new world order where the state is not disappearing but disintegrating, and international organizations are primarily convening structures of horizontal networks. But while the importance of networks is increasingly accepted, most lawyers have not drawn any conclusions of this finding. And ladies and gentlemen, some of the most important recent developments take place on the margins of current concepts of its international law. And I refer in this context, inter alia, to the cooperative undertaking of regulatory agencies. Because the power and importance of these agencies, of these cooperative undertakings, which incorporate some of the most powerful agencies of states, such as central banks, is reversely proportionate to the attention given to them by lawyers. And if you see the developments of, for example, of the Financial Stability Board, which has had a substantial progressive institutionalization and was really incorporated under Swiss law, I don't see a justification to exclude per se all sub-state, all regulatory agency from the realm of international organizations. And perhaps another provocative thought, I would like to argue that private sector entities can be full members of international organizations. For example, in some cases, countries provide assistance through entities, either through agencies like Danida or CEDA, who are part of the Ministry of Foreign Affairs, or like KfW or GIZ, who are organized as corporations. In either case, they are fully owned and under the control of the government. But I want to make the case that institutionalized participation of private sector entities may enhance financial support, and it is also help substantially the organization to enhance its knowledge base, because the staff resources of international organizations, matters like reinsurance, export credit, value-added chains are tiny in comparison to the huge resources of reinsurance companies and other things. And here, I would like to make the point that it's possible to fathom an organization whose membership is entirely composed of private sector entities, which would imply a reversal of traditional governance structures, as private sector entities would take decisions and states would be involved in advisory capacity. and ICANN, which administers the internet, the international standards organizations, and IATA might be possible candidates for a conversion of that type. Such an organization could be established following the CGR paradigm by states that do not become members of the EU. Let me conclude on this one that the full membership for transnational actors should be a design option for all new international organizations. For existing organizations, it may require amendment of constituent agreements, which are formidable obstacles for reform. But, as I will subsequently indicate, short of such amendment, multi-actor features might be introduced through secondary governance structures. Let me add a few more points on this matter. The first two concern the current static concepts of international organization and the requirement in literature that entities need to be established by treaty to qualify as an international organization, and I disagree with both proposals. May I recall, as Justice Alvarez remarked more than 60 years ago, while formally rules of law evolve slowly today, because of the social upheaval, the dynamism in the lives of people, the elaboration of such rule is rapid and sometimes even sudden. And Paul Schasch, the former director of the General Office of Legal Affairs of the United Nations and distinguished scholar, says human institutions show many traits of biological systems, including a striving to grow as fast as resources allow, a tendency to proliferate, and a resistance to annihilation unless survival is assured. There's many examples of progressive institutionalization, and I've listed them here, and there are many other examples, and the road from a non-governmental organization to international organization has become a two-way road. Therefore, it clearly somewhat escapes me why invariably all textbooks refer to the establishment of the international organization to determine their status. I view the status of the organization at the time of its establishment only as a snapshot of its powers and functions at the time, and believe strongly that rather than static concept, a dynamic concept of international organization is required, not only to comprehend international organizations, but also to comprehend the dynamics between their governing bodies. As regards the second proposal, traditionally, we all know that the definition of the Vienna Convention on the Law of Treaties and the statement of the International Court of Justice that constituent instruments of IOs are also treaties of a particular kind. And Peters and others see these two facets of a constituent agreement, the treaty facet and the constitution facet. And indeed, ratification of a constitution implies force of law in member countries. It has distinguished features. Nevertheless, international organizations do not need to be established by treaty, but they may be agreed, for example, created based on an international agreement that does not qualify as a treaty, and such as agreements between Ministry of Finance and central banks. And sometimes you hear that these are not treaties, but the question is, what are they? And I wish to recall that already 40 years ago, the UN Office of Legal Affairs stated that the rule of that an international legal person is created by treaty is nothing more than a rule of customary international law. And they questioned whether a new rule of customary international law is emerging, by which an international legal person could also be created by autonomous entities. And we have various other paradigms which have emerged. Basically, organizations established by resolution of a conference, adopted by a constitution, by governing bodies, based on acts of national law, establishment of a conference, or merely by consensus. And here, the interesting thing is that a constitution adopted by a plenary body may regulate institutional matters, but may recreate an internal legal order, and that is important. It may also be a basis of international action. And here, even the United Nations Office of Legal Affairs, which is a bulwark of traditional concepts of public international law, has recognized that the substance of a constitution may be more relevant than the intergovernmental, than the agreement which is cast. And it has recognized, in the case of Interpol, that a non-governmental organization may change its status to intergovernmental. And I also wish to refer to the famous joint opinion of Ian Brownlee and Guy Goodwin Gill on IPU, where these have indicated that while there's no treaty foundation in case of IPU, the IPU statutes have a similar function. And let me add here, because very interesting in development in the recent government is that new organizations are emerging which are more akin to the treaty regime than to traditional organizations. And the Multilateral Fund for the Montreal Protocol sets the pace. At the time, the Montreal Protocol was still amended through the London Amendment to provide the basis, but the actual establishment was then, and the legal nature of the multilateral fund was then clarified through a decision of the meeting of the parties. And we have the preparatory commission to the Nuclear Test Ban Treaty, which was established by a resolution of the state signatory to, and here the Green Climate Fund. The Green Climate Fund is different from the Montreal Protocol because in that sentence, in the case of the Green Climate Fund, the United Nations Framework Convention on Climate Change was not amended to provide for the establishment of the GCF. Rather, the UN FCCC COF decided to establish the Green Climate Fund, and it's quite contentious whether they actually could do that. Well, and in practice, basically, it was left to the decision of the parties. And I can tell you only from my own experience. I have negotiated for the Green Climate Fund, the headquarters agreement with the Republic of Korea, and something like 20 other agreements. And based on this recognition by so many parties, I believe it can duly be said that the Green Climate Fund is an international organization. Let me also refer to the explanation of Gaius as rapporteur of the. He had proposed not to incorporate into the treaty as a matter of the definition of international organizations. I do not contest that frequently international organizations are established by treaty, but in my view, it should not be a part of the definition of international organization. And in essence, it does not matter how an international organization is established. What matters are its powers and functions and the position which recognized international objects of international law have adopted in this regard. The next point to which I want to come is the public-private dichotomy, which is one of the main dichotomies of public thought. And as I've put here, I think the borderline between public and private law is moving, and is moving also in the field of international organizations. While in the past, the rather crude form of indicating this similarity by distinguishing the state and everything else has led to the assumption that organizational structures not established by agreement with states, etc., do not fall within the realm of international organizations. If it was ever appropriate, this assumption is no longer appropriate now. And I already showed that in case of ECOSOC, while initially ECOSOC classified Interpol as a non-governmental organization, this was reversed, and it is now recognized as an intergovernmental organization, and the same took place in case of the IPU, case of IPU. Now let me come to the emergence of a new class of dual and hybrid organizations. These are now a well-defined feature of the international architecture, and it's long since recognized in case of the ICRC that personality may be acquired by a combination of treaty provision and recognition acquiescence by other persons. In my view, the time has come to take the ICRC out of the niche of atypical subjects of international law, where it has been placed with the Order of Malta and the Holy See, and recognized as a predecessor of a new class of dual and hybrid organizations incorporated under national law, but with recognition of international legal personality. And the Global Fund to Fight AIDS and the Gavi Alliance are epitomes of this new class of international organization. And here is also, I've already mentioned ECAN, which shows that private entities established under private law may produce public goods. And I now want to, in view of the time, speed up a bit my PowerPoint and deal together with the international legal personality of organizations and their autonomy, because both are seen as a corollary of each other. There cannot be a question, a doubt about the importance of legal personality. And and under the current theory, the constituent agreement establish international legal personality, and being a subject of international law is the consequence of an organization possessing international legal personality. Nevertheless, I believe that the current theories need to be revised and to a substantial extent. As international legal personality may also, organizations may be endowed with international legal personalities also after they are established based on progressive institutionalization and the adoption of a constitution. And legal personality is not a requirement for the classification of an entity as an international law. The question arises in limine whether it's necessary to have a concept of personality of international organizations. And consistent with the reparations of injuries, that an organization is an international person can be taken to mean that it's a subject of international law. However, the opposite is not true in my view, and there can be subjects of international law that are broader than international legal personality, such as entities established as trust fund, dual or hybrid entities, or organizations characterized by institutional ambivalence by design, such as the Organization for Security and Cooperation in Europe. On the next point, I want to be very brief. The point here, which I'm trying to make, is traditionally, autonomy of an international organization was seen as the corollary for its establishment by treaty. However, this is, in my view, not the case, because you see organizations such as the Green Climate Fund, you see organizations such as the Global Environment Facility, established as a trust fund of the World Bank. These organizations have autonomy, and I'm therefore proposing that we need to adopt new concepts where recognized that autonomy is not necessarily derived from a treaty. And I'm proposing a new analytical framework in the book, which is not based on membership, it's not based on the establishment by treaty, and it's not based on international legal personality. And under this framework, basically, the relationship between international legal personality and subject of an international organization is as follows. If an entity possesses international legal personality, it necessarily qualifies as a subject of international law. However, the subject of international law is broader than international legal personality. Therefore, there can be subjects of international law without international legal personality, and I mentioned some of those, such as these entities established by trust fund. International organizations operate at the international plane and all subjects of international law for that reason. However, the term international organization is wider than that of subject of international law, and there can be indeed subjects of international law which are not international organizations. For example, it's discussed regarding the Conference of the Parties, and the UNFCCC COP clearly, according to legal opinion of OLA, has international legal personality and is a subject of international law, but it's quite doubtful whether it's an international organization. Let me add with a few additional provocative thoughts. The traditional approach is that international organizations can only create subsidiary bodies, but not new international organizations. And this argument appears to be compelling at first sight. Nevertheless, it can be maintained, in my view, that the power of creation of new AOs has passed over to international organizations and other actors for the following reasons. The creation of institutionalized forms of cooperation is no longer necessarily based on the treaty. It can also be created by agreements between international organizations or resolutions, etc. Furthermore, an entity does not need to have all the trappings of IO when it's established. It's sufficient for international organizations to lay the foundation for an entity which subsequently acquires international legal personality and status of IO based on progressive institutionalization. There are a wide range of entities which may be transformed into international organizations. And there's a new paradigm which I referred to in case of the Multilateral Fund, in case of the Green Climate Fund, where new entities are established based on a conference or a meeting of the parties to a multilateral convention. And finally, and this potentially in the long run might be the most important way of creating new international organizations. International organizations may sponsor the agreement of new international organizations as trust funds or dual hybrid organizations. And in this case, it is not a delegation of authority, but a sponsoring, and therefore the limits for normal delegations do not apply. I would like to summarize, as I'm over with my time, the remaining points rather briefly. This whole relationship, membership has many implications for institutional structures, and you have in international organizations this normal three-tier structure with a plenary board and a governing body of limited membership and a secretariat. But this three-tier structure is increasingly under review and being criticized, both regarding its functionality and regards its inclusiveness. And therefore, some organizations, such as the Global Fund to Fight AIDS, have moved from a three-tier structure to a two-tier structure, including a partnership forum which comprises a number of stakeholders. And the point I'm trying to make also in my book is that in certain cases, it makes benefits can be derived from transforming an organization in a multi-stakeholder organizations, because, for example, if you want to involve, for example, in the way of transition to a green economy, private sector entities in this transition, you need to have a structure where you also can involve private sector entities. And one of the things, and perhaps I can illustrate this if you want in the context of the discussion, is that secondary structures can be created under the purview of overall strategic frameworks are adopted by international organizations. A last thought before I conclude. The above has far-reaching implications also for the funding arrangements for international organizations. Traditionally, organizations are funded exclusively through contributions, nearly exclusively through contributions of members. But I highlighted already, these funding mechanisms do not work properly for organizations producing global public goods or fighting global public bads. And these organizations should ideally be funded through global levies or charges. And there we have examples here, for example, in case of the adaptation fund, which was prior to the collapse of the carbon market, funded by 2% of the levies of the clean development mechanism. And we have other entities which are funded through global taxes. And it is important for international organizations to open themselves to try to fund new funding sources, and it's in particular important in areas like the transition to a green economy, because the costs for the transition to a green economy are estimated in the range of $90 trillion, from 10 to 90 trillion. These are staggering amounts, and all the traditional funding mechanisms are inadequate to provide these amounts. And the only way how to get this funding is if you offer the private sector, for example, bankable projects for investment in the green economy, which is possible because these investments are fully adequate and just on economic grounds, without the additional positive societal implications. Let me conclude with this, that in my view, new concepts of membership, but also a range of other new concepts of such as subject of international law and new operational frameworks and funding frameworks for international organizations are required. Thank you very much.
Thank you very much, Dr. Droesse. As I said in the beginning, now will be the time for questions and answers. We already have the first question coming in, and if you have any other questions, please enter it into the Q&A section. So the first question that we have is the following one. And sort of, I think it picks on your key argument and looks at implications more broadly. And I suppose one could say that your argument has been more directed at the desirable side effects of having a new conception. And the question, I think, rather tackles the possible concerns. The question is this: how do you envisage immunities for international organizations in light of the broader private actor membership advocated? Could this be a way to allow private actors to circumvent or to avoid liability?
It's a very interesting question. And well, I personally, for example, let me take the example of the Global Fund to Fight AIDS. It is possible for entities like this. It is established under Swiss law, but it possesses full international legal personality and privileges and immunities equivalent to those to that of the UN agencies in Switzerland, including full diplomatic status for staff members at level 5 and above. And for example, just a few days ago, the Global Fund to Fight AIDS had entered into agreement with a number of the states where it's operating, which recognizes its legal personality and provides for privileges and immunities. And it took more than 10 years for this multilateral agreement finally to take effect. So it's possible for an entity such as a global fund to have privileges and immunities. But indeed, the question is, and that is a very legitimate concern, one should not give international organizations protections, which they do not deserve. And I want to mention in this context the international satellite organizations, which were actually privatized, essentially due to this concern that they had an undue advantage in comparison to competitors. And so the road between international, intergovernmental, non-governmental and international organization has become a two-way road. On the one hand, you have entities which convert to an international organization from a non-governmental status. And on the other hand, you have certain entities which are demoted, in particular due to this concern that they may have an undue advantage.
Thank you. So the next question is sort of a broader one, and I think that is something that I was also thinking in my own way about during your presentation. Recognizing that various organizations discussed by you, that to recognize that organizations are international, quote unquote, would have consequences. So personality, as you said, with a nod to the classic reparations case, has certain implications. Would these consequences need to be conferred or approved by states in some way? Again, at the broadest possible sense, either at the time of the constitution of the organization or at some later point in order for them to be effective?
We have some very interesting examples. For example, I think a year ago, for example, the Global Fund to Fight AIDS was accepted as an intergovernmental organization by the United Nations on the basis of a legal opinion prepared by Professor Reisman, who had given a legal opinion on the intergovernmental character of the Global Fund. And there are a number of cases where the specific instruments reference international organization or intergovernmental organization. And the interpretation of these instruments is different. For example, under the article, I think 6 ter of the Paris Convention on WIPO, WIPO sticks to the very traditional definition of intergovernmental organization. But there are other cases, for example, and I discussed this personally with the Court of Permanent Arbitration, where somewhat more flexible opinion is adopted. And for example, in case of the ILO Administrative Tribunal, international organization, the Global Fund to Fight AIDS was accepted as an international organization. So it really revolves on the, I think, interpretation of the word intergovernmental organization and international organization. And I think there are increasing cases where it is accepted that organizations such as the Global Fund, other organizations without a treaty base, and I also want to mention IPU and so on, are deemed to be international organizations, also for the purpose of legal effects, which are provided for by specific legal instruments.
Before I pass on to the next question, I think we really have quite a few coming in. Are there any examples where states would have been pushing against this? So I think you have given a number of examples just now where a broader conception has been adopted or at least tolerated by states, parties, and relevant institutions. Are there examples where states are pushing explicitly against it, where the states are explicitly saying, well, this falls a bit outside our traditional conception and we'd rather not?
There are always different views, but I'm not really aware where this was. Certain countries surely have certain more restrictive opinions on the matter, but I'm not aware of any case where it really has become a major issue in case of an international organization.
All right. So the next question sort of picks up on, I mean, you already mentioned the ILO. And so the question goes to the ILO tripartite structure, which involves classically, of course, since the interwar times, not only government, but also trade unions and business associations. How would that fit within your argument for reconceiving membership of international organizations in a novel manner?
Well, I think the ILO shows that under, I think the annex, if I'm not mistaken, of the Convention on Privileged Immunity of the specialized agencies, I think also the workers' representative and are covered by certain privileges and immunities. So I view the ILO as, if you want, the tripartite structure as an of the ILO as a predecessor of more recent sort of trends to more multi-actor constitution of governing bodies. And I can also give you an example out of what we tried to do in case in Dubai, which is still ongoing, the effort. But we tried to establish the World Green Economy Organization as probably one of the first multi-actor institutions, because you cannot have an institution which seeks to facilitate the transition to a green economy if you have a governing bodies entirely composed of government representatives. And therefore, we tried to establish it as a very first sort of full-fledged multi-stakeholder organization. So the answer, I think, is I view this ILO as a predecessor of new trends and developments towards a more multi-actor institution of international organizations. And I personally see a substantial benefit, at least in case of some organizations, for such transformation.
Well, I think it's in some ways it's pleasing that ideas that were novel a century ago are still cutting edge in contemporary practice.
Yeah.
To push on with the next question, so the next speaker, the next question asker, accepts the basic point that composition of organizations has changed fundamentally, and nods to the 2001 International Law Commission's articles on responsibility of international organizations as confirming that view. But I think what the concern is in this question is to accept your argument more generally. Shouldn't one start with an argument for recognizing private, so I suppose non-state actors in the broadest sense, like multinational corporations or foundations such as the Gates Foundation, obviously in the news in the recent month in the context of the World Health Organization, as subjects of international law. And so the tenor of the question here is a bit skeptical of recognition of such magnitude, with the possible exception of certain specialized fields of international, like investment law, and perhaps we could say human rights law. In general, the personality fabric seems to be still pretty conservative in international law. What would you answer to such a skeptic?
Well, I think there needs to be a limit. First, it needs to be an international organization, which means first it needs to be an organization with established sort of organization structure, etc. And it needs to we cannot obviously take any entity which operates in any field. So I still would require for international organization that it is an organization, that it has political autonomy, that it has institutional independence, and that it operates or that it has duties and responsibilities under international law. And I think we cannot, well, there's the fact is that the group of actors in the international arena has very much expanded. And I see also in this vein, I see these this Global Fund and the Gavi Allowance and other organizations as a new business model of international organization. And I believe it can very well be justified that these are subjects of international law. Also considering the overall expansion of actors, and as you mentioned, there's all sorts of theories that liberation movements or the international investors on subject of international law. But I think it can very well be justified that, for example, this class of dual and hybrid organizations are subjects of international law because, like the Global Fund, they have now recognition of their legal personality in a multilateral agreement, which was signed by more than 10 countries. So I think this is a very new paradigm for dual and hybrid organizations being covered by a multilateral agreement providing for privileges and immunities. So I personally think that there's a very good basis. I also see, for example, if I may see, organizations such as the Organization for Cooperation for Security and Cooperation in Europe, OSCE. I personally see those as international organizations. And that even before the recent adoption of headquarters agreement between Austria and Poland, which implicitly recognized the legal personality of OSCE, because even before you had OSCE was acting, even though not provided with international legal personality, was acting at the international sphere, for example, through memoranda of understanding with Ukraine, which were ratified, for example, by the Parliament of Ukraine. But I personally, for example, OSCE, I personally saw them as international organizations even before the recent developments. But after the recent adoption of headquarters agreement, I personally don't think there can be much doubt that they have international legal personality also and can be classified as international organizations.
So the next question is sort of perhaps goes at a higher conceptual level. And it goes for the distinction between subjecthood and international legal personality. And the question asks, sort of assuming that if one were to accept that international legal personality comes in all shapes and sizes, for natural persons, states, international organizations, and others, what would characterize subjecthood as a distinct and broader legal concept? Do they collapse together under your argument?
Yes, under my view, and there are others like, for example, Fried in relation to the Union in her book had a similar concept, but I personally see subject of international law as a wider concept. So while necessarily in all cases where an entity has international legal personality, this entity is a subject of international law, there can be, in my view, entities which do not have legal personality which can be classified as subject of international law. And I wish to refer here, for example, to the Global Environment Facility, which is a trust fund established by the World Bank. And it's very clear, as the quest of the GEF for international legal personality was not successful, it does not have international legal personality, but it has all the other, it has a governing bodies which proper will, and it acts at least through memoranda of understanding, through at the international plane, through agreements with the international conventions. So I personally see, for example, this GEF as an entity which does not have legal personality, but is nevertheless to be classified as a subject of international law. And this can be also relate to other entities established by trust funds. And I'm not referring in this case to normal trust funds, but only to entities which have a proper autonomy governing bodies like CGF. And I personally find also the case of these dual hybrid organizations, such as OSCE. I personally see that these can be subjects of international law based, for example, on the analysis of the OSCE obligations, because the fact that these agreements, for example, that the obligations of OSCE were not adopted formally through a treaty base does not mean that they are not legally binding. And there's increasingly recognition, for example, for entities like OSCE also to be classified as a subject of international law. So in that sense, I personally think that subject of international law is wider than international legal personality, as it comprises necessarily all entities with international legal personality, but in addition, it also comprises entities such as the Global Environment Facility, such as OSCE, which have not been endowed formally, at least with international legal personality by their members, but which effectively act at the international plane.
Well, I cannot resist myself from abusing my position as a chair to ask a concluding question that I have on my own. And I suppose it's sort of, it goes perhaps particularly to the first part of your talk about the peculiar challenges for international organizations that address global public goods and global public bads, and that we have to in some ways move beyond the traditional club and contract concept. Yeah. And I suppose that is, one could say, that is not a concern limited to international organizations law. We are familiar with the instinct that there's more to international law than egoistic transactionalism from law of treaties and law of international responsibility, particularly state responsibility. But I think one answer as well that we get from state responsibility is that international law is extraordinarily resistant still to the multilateral elements at the level of default rules. Apart from certain elements on implementation and invocation of responsibility, very rarely exercised in practice, and possibly certain consequences on peremptory breaches, again, very rarely operationalized. I would say perhaps a little bit cynically that the international law of responsibility is still largely bilateral, and to the extent that states want to go multilateral, they have to make a political choice to do so, as it were, by providing explicit rules. So if my general takeaway is right, that international law is still resistant to communitarian instincts as a matter of default,
Yeah.
Would that be a cynical response to your argument that you may be right at the level of normative intuition, but that should not lead us to change our conceptual framework, but simply to change our politics? In other words, we don't need to change the way how we think about international organizations, but rather the way how we act within international organizations.
Well, I would agree with you that international lawyers are generally very conservative. It's perhaps you can remember, as Crawford has said, that under the League of Nations, actually, the Secretary General had to sign contracts of employment in his own name because there was not generally exceptions of the legal personality of the League. And in the same vein, I think international law has been particularly resistant to take account of sort of the diversification of actors in the international arena and so on. But I think it's time, and I personally think it's time to adjust international law to the to reflect the development of international law, which already took place. And I think recognizing dual hybrid organization, recognizing a wider range, a wider concept of international organization, I personally think only reflects the developments of international law which already took place.
Well, thank you. Thank you, Dr. Droesse. I'm sure that listeners also benefited greatly from this concise argument of taken from the whole book, which I'm sure I would join wholeheartedly in recommending everybody to acquire. And also, I think a normatively very attractive and inspiring message of communitarianism and progressive values in contemporary international law. Well, many thanks for joining us, and the recording of this lecture will at some point, probably in December, be available online if you want to come back and to follow some of the slides as well. Many thanks indeed.
Thank you. It was a pleasure.